Representative Larson. Representative Sherwood. Representative Stith.
Here.
Representative Walters. Representative Swanitzer.
Here.
Chairman Nicholas.
Try to get these, we're going to do the kind of the quicker ones first, I think, so that we have less people waiting as we go. So I think the first one we'll do is Senate File 138, unemployment insurance coverage. Senator Kolb, come on up. Welcome. Just briefly, let's just walk us through the bill real quick.
Thank you, Chairman Nicholas. Would you like me to explain the?
Yep.
Well, this is an appropriation of $18,000 for updating and administering the Wyoming unemployment insurance system. And that's the purpose of it. I'll stand for questions.
Mr. Chairman. Senator Cole, this is a direct referral. This isn't a re-referral for the appropriations. This is for your bill. You need to explain it to us just like.
Oh, well, I thought it was just a referral. Oh, well.
And
I wish I would
but
have.
that was quick.
Senator Cole, wish he would have realized that. Well, this bill changes the amount of unemployment insurance time from 26 weeks to 20 weeks. It also changes the extended uninsurance multiplier in half. From 13 to 6.5 times the weekly benefit amount under this article for week of total unemployment in the applicable benefit year. That is, in fact, a federal call on the extended benefit program. The main purpose of this bill is to lessen the time of unemployment, to get our folks back to work a little quicker. The time period was amended in the Senate from 13 weeks to 20 weeks on the request of the Department of Workforce Services, as that would be the least detrimental to the current system. There is currently in the state of Wyoming 22,000 job openings, and in fact 3,050 people on the unemployment rolls. So this is a small step forward to get people back to work a little bit sooner if that's the case. I will also say that the average time for the unemployment benefit is in fact 13.7 weeks, if my memory serves me correctly, and this is far above that for the time period of unemployment benefits, above the average. Mr. Chairman, I was not totally prepared. I didn't realize this was the
That's all right.
referral, so that was bad on my part, Chairman and members of the committee. And I'll do my best to answer any questions you may have.
Okay, any questions for the senator? Representative Walters.
Thank you, Mr. Chairman. Multiple locations, you changed from unemployment insurance to re-employment insurance. What was the reasoning behind feeling it was necessary to change that vocabulary?
Mr. Chairman, Representative Walters, it was to change the state of mind that instead of being on unemployment, you're on re-employment, which is in fact, I think, our goal to get our people re-employed as soon as possible. So it was probably more of just a statement of what the program should be about, and it's about re-employment. I apologize for not mentioning that when I explained the bill.
Further questions? Representative Stiff.
Mr. Chairman. So Senator Kolb, is the purpose here then to say that because the average time on unemployment is 13 weeks, that we don't need the term to go all the way to 26 weeks, and that if you shorten it to 20 weeks, then we both save money and get people reemployed faster? Is that the purpose of this file?
Chairman Nicholas, Representative Stith, yes. The fiscal note, in fact, denotes that it it will be a savings in the cost to the employers for this change in the program. Obviously, it's not 13.5 weeks now, it's 20. So there is noted in the fiscal statement that it is in fact going to be a savings or a credit in the case of this benefit change.
So what's the impact of changing the multiplier from 13 down to 6.5?
And I asked that question with the Department of Workforce Services, Mr. Chairman, and it was negligible because the program does not get enacted. I mean, it's a federal call on the program for that. I think that's certainly something we can discuss if you'd like to amend that to some other multiple number, but it became a moot point in that it wasn't used. I think the department could probably explain that better than I about how that gets enacted. It's a federal call, not a state call for that extended benefit program.
Okay, further questions for Senator? Any comments? Come on up. Workforce Services. Maybe you can answer my question.
Thank you, Mr. Chairman, members of the committee. Could I please ask to allow Chris Funk, our UI administrator, into the room, into the Zoom room too? She's on. Fine. Mr. Chairman, members of the committee, my name is Robin Cooley, and I'm the director of the Wyoming Department of Workforce Services. I have with me today Administrator Holly McCamey-Simone, who is our Workforce Programs Administrator, as well as Chris Funk on Zoom in the Zoom room, who is our UI administrator there in Casper. And thank you for the opportunity to speak to you about this bill and about some of our concerns relating to this bill. We've had a little bit of chance to further vet the bill. We didn't have a lot of time, but the last couple of weeks, as we've really gone over it, we've recognized some additional consequences or some additional impacts from the bill that we're concerned about, that we'd like to just make sure that you're aware of as you move forward. One of the things that is the most concerning to us is that in moving forward, we've recognized and we've researched that there's other states that have done the same thing. They've reduced the numbers of weeks. What they've done that for in a lot of cases is because their unemployment trust fund is not healthy. And the impact of reducing weeks, of course, is going to be to increase the health of your trust fund. And that's not an issue we have. In additional circumstances, there are other reasons that they would do it that just that are just not relevant to Wyoming's situation with the health of our trust fund. So we have not been able to find any research or empirical support that suggests that reducing the number of weeks of unemployment benefits has the effect of actually putting people back to work. It might get them off of unemployment, but we don't know for certain that it does actually put them back to work. So that is a significant concern of ours. If you look at our surrounding states, in fact, all of them have 26 weeks with the exception of Idaho, which is at 20 weeks. But I would argue Idaho's economics and their situation is far different from Wyoming's. And so comparing Wyoming to Idaho's 20-week change would be comparing apples to oranges, I believe, just because a lot of that is our boom and bust economy that we're considering. That takes us to our next concern that we're really, that we've looked at a little bit more, and that is the impact it has on our very highly skilled, highly paid workers around the state. And when we were looking at this, we were really thinking about when we see layoffs, and we really need to have individuals have that ability to use our unemployment benefits. We're seeing layoffs in our coal miners. Sometimes overnight, we've got coal miners that need to access unemployment. Or we see a reduction in an entire industry or layoffs in entire industries like the oil and gas industry. Those individuals are highly skilled, highly paid, and they need the ability a little bit longer time in order to walk out and in order to find additional employ or find other employment. And if we could, you know, in Wyoming, we know we've got openings in retail areas. We know we have openings in restaurants and in hospitality. I don't think there's an issue there in having people get on unemployment for a short time and then get off and get into those kinds of jobs. We know that those jobs are available. With these other types of positions, we just don't see that. And in fact, when we did a data poll from 2019, when we had some of those layoffs, it really was those highly skilled, highly paid workers that were taking advantage of the unemployment benefits for a longer period of time in order to find employment. And we are just fearful if they don't have the ability to do that and they're not able to find jobs, that they're going to be leaving the state. Another concern that arose as we were vetting this further was the impact it might have on approved training programs. We've all been talking about that this session, about apprenticeships and internships and these on-the-job training programs that we all want to promote and have from our K through 12 on up, so that we can have people getting the advantage of those on-the-job programs. And an example of the impact on that are the electrician apprenticeships. With those apprenticeships, they will go into a schooling situation for a period of time, and then when they're not working, but their job attached to an employer, they will then go into the on-the-job training for a period of time where they will be earning wages, and they're actually a regular employee at that time while they're apprenticing. What they do when they're in the education component of that apprenticeship is they are able to draw unemployment insurance benefits that helps them to pay ongoing expenses while they're not working. So they're going back and forth with this unemployment benefit program, and there's a real benefit to that to keep them in there and help them pay some of their bills. And that's not just for the apprenticeship programs. We've got individuals that are doing it that have the benefit of our WIO, our Workforce Innovation and Opportunity Act funds that are in school. They might be in school and they're going back and forth between a full-time job and then going to school. They're also able to take advantage of those weeks of unemployment. We're afraid if we reduce those weeks, that's going to impact the ability for those on-the-job training programs as well. And that is something that we just were able to vet, and we're able to really come up with a situation where we could tell you there is a scenario that is going to impact with the fewer months or the fewer weeks that we're talking about. One other point that I want to make sure everyone is aware of is I've heard some rumblings that the training fund grant dollars are impacting the ability to pay unemployment benefits, or there's somehow a correlation between the training fund grant programs that I think all of you have heard about, where we're paying for training for existing employees, we're paying for internships, and there's a correlation here. Those are two separate things. They're two separate funds. To explain just a little bit further, the Unemployment Trust Fund is actually the federal fund that is overseen by the Department of Labor. The state of Wyoming many years ago set aside an additional state fund. That fund can only be tapped in the event that the actual federal fund is depleted. And it contains a pretty steady amount of funding in it. It's about $51 million that stays in that fund. The interest off of that fund are the funds that pay for all of the training fund grant programs. So they're two separate things. There's no mixing here. There's no impact from one on the other. So I want to be clear that there's nothing there that's impacting either one of those programs between those two various programs. And lastly, but maybe most importantly for our purposes, we have very real concerns that this bill will reduce our ability to provide employment programs across the state in our workforce centers and throughout our agency. When businesses pay their taxes into the unemployment trust fund, those funds are not just used to pay for benefits for unemployed workers. Those funds also go into a separate fund called the Employment Support Fund. That Employment Support Fund is used to fund all kinds of programs in our agency, whether it's vocational rehabilitation, it's programs for our veterans, it's programs for adults that walk into our workforce service centers around the state that don't have any other ability to get assistance to find a job. They need help with resumes, they need help with interview assistance, whatever it may be. It's our youth. It's our programs for our youth across the state. So the Employment Support Fund, which is also paid for from these funds, help to fund those programs across the state. The way the program is set up in statute is the Employment Support Fund monies flow into a separate fund, and they are all dependent on benefits paid out of the fund. Seems counterintuitive, but that's the way the statutory factors are calculated. So if benefits paid out are reduced through reduced weeks, then the funds flowing into the Employment Support Fund are lessened. That means less money for us to pay for some of these other reemployment or employment programs. Now we tried to.
Go ahead.
Director Cooley, I hear you, but I don't know that I'm tracking that. Can you just kind of give me a little example how that works? Because you're right, it doesn't sound. It sounds weird. I'm trying to get my head around that.
Mr. Chairman, Representative Larson, it's complicated, and I will try to explain it. And if I can't get it, if I can't explain it, we'll ask Chris Funk to do that for you. Money that comes in from businesses to pay their taxes goes into a clearinghouse fund. From the monies that come in, there are statutory factors that calculate how much money should go out into different parts of the fund. If monies are paid out incorrectly for whatever reason to a claimant for benefits, and we determine that they were paid out incorrectly, they need to be charged back to that employer. That's called the ineffective it's called the non-charge or ineffective charged factor. And that's specifically in statute. So that's a pool of money that we recognize should be recognized as incorrectly charged. The statute requires 60% of those funds go right back into the Unemployment Insurance Trust Fund. But 40% of those funds then go into the ESF fund, the Employment Support Fund. So if we have less non-charged, ineffectively charged funds for benefits paid out, then there's going to be less funds that go into either one, the UI or the Employment Support Fund from that. It is complicated, but that's how that works. So that reduces our ability to provide services across the state in some of these very important programs. And I think I did mention those to you. So we've got a very real concern about that. There are ways to talk about adjusting those funds. But the problem here is these funds all intertwine, they all work together. It's all a statutory formula that fits together. If you take one part of it, like we have with this bill, and and I don't want to use the word, you change one part of that, the rest of it throws the rest of them out of whack. And we're just not really sure, based on economics, based on inflation, based on any number of things, how that's going to change some of these factors and how it's going to impact the fund. And I say that, here's a for instance. When we were keeping our eye on the UI Trust Fund, because as you know, we provided credits. Once we had CARES Act funding flowing into the UI Trust Fund, we provided credits. We kept our eyes on that fund because we thought that fund was going to go down. When that fund goes down, then tax rates are supposed to go up because that's how the balancing is. The tax rate goes up in order to keep that fund at a very healthy level. What actually happened is we had so many new business openings with paying new taxes into this fund that it actually went up. So those are the types of things that are all dependent on this that we have no control over. And so we're just a little concerned that we're touching one part of this factor, we're touching one part of this equation, and we're not giving adequate consideration to the rest of it. Now, I want the UI Trust Fund folks in Casper know their jobs, and we are ready to recognize that there needs to be some adjustments to this, to these factors and to this calculation. And we say that because this was actually done quite a while ago and there's not been a lot of change. The dynamics in our workforce have changed. The dynamics in our economy has changed. So let's take a look at it, but let's do it more holistically so that we're looking at all the parts and pieces, and we're really doing it so that we know or have a better idea, I would say, where the implications are and what some of these difficulties are going to be and where we can make appropriate adjustments to account for them. I need to add one final point, if I could, as it relates to the Reemployment Commission and renaming the commission. When I had spoken with Senator Cove first, I like him. I really like the idea of unemployment being reemployment, because that's what it is. It's not a system where you stay on it for a while. It's not a welfare system. It's a system that's for the communities. It's for the individual and the communities to put money back into those communities. But we want reemployment. We want it to be recognized as reemployment. And so we don't want that stigma of unemployment. But at the same time, in reality, the UI Commission only has the authority to hear appeals from agency decisions. And so renaming them the Reemployment Commission might cause some confusion, both to claimants that are moving from the Unemployment Commission and an unemployment insurance appeal to the Reemployment Commission, when they really don't even have the legal ability to provide advice to claimants. So those are our concerns in a nutshell. Again, we're open for change, but we need to very carefully consider some of these options. And we're happy and stand ready to help with that if you should decide that this should be an interim topic instead. And with that, we will stand for any questions.
Mr.
I do have a question. You, in your fiscal note, it says that there are roughly 12,000 recipients for 2019, and that's been the last time you had the data. And of those, 2,900 had more than 13 weeks. My question is, how many had 20 weeks? And then, or do you have this on a scale so we can kind of see the scale of where that really falls off or how that plays out? And it's kind of, because of COVID and all that kind of stuff, you probably need a long-term view of that to have a better picture of it. So do you have that information?
Mr. Chairman, members of the committee, we had gotten a number when the bill actually was at 13 weeks, was going to be cut back to 13 weeks. We had at that point of time 88 workers that went beyond that point. And those were the highly skilled, highly paid workers that we're talking about earlier. We have not been able to pull the data for that 20-week time frame yet, but you're absolutely right. I think we need some time to really do it over a span of maybe 5, maybe even 10 years in order to determine what that looks like for that period of time. We just haven't had a chance to do that yet.
How long has it been at 26 weeks?
Mr. Chairman, to my knowledge, that's where it started out at. And yeah.
Other than the states around us, I mean, what are other states? Do we have that information?
Mr. Chairman, members of the committee, there are 10 other states that have differing weeks. 2 have actually more than 26 weeks, and the other 8 are less than 26 weeks, around 16 and 14 and 12 and 10 weeks. That's a nationwide look.
And then the other question I had is, what's the status of the unemployment trust fund account? Is it healthy? Is it? Go ahead.
Mr. Chairman, members of the committee, as of January 2022, we are #1 in trust fund solvency. Historically, we stay in the top 3.
Any other questions? Representative Stiff.
Mr. Chairman, Director Cooley, and this perhaps may be a very similar question. If you know, the average is 13.7 weeks of unemployment. Do you, any idea what the standard deviation is? That is, how many people fall within, 18 weeks?
Mr.
If you know.
Chairman, Representative Stiff, excellent question. The average is actually 14.7 weeks. Just to be accurate on that, but I don't have that deviation, but that would be another point that it would be beneficial to see that, I think, moving forward.
Go ahead, Representative Henderson.
Operator, sorry. You mentioned a couple of times, the people with higher technical skill areas. Could you share just an example of some of those that are more difficult to find employment or re-employment?
Mr. Chairman, Representative Henderson, we see those highly skilled, highly trained individuals in our mineral occupations. So it is typically coal miners, oil and gas workers that have very technical, highly qualified skills that are very unique to that industry. So for example, say you're running one of those really large dump trucks that take a very specialized skill. If the coal mine shuts down, and we saw this at Black Jewel, it's very difficult for them to go get a similar paying job in that community that heavily relies on highly skilled, highly trained workforce there. And it's going to take them some time to get their feet underneath them, apply for UI, and then get back into the workforce. And sometimes that requires additional training and additional certifications. And then we can help them with those transferable skills, pivot into the workforce, and hopefully keep them here in Wyoming as well.
Appreciate that. Thank you.
Further questions? Okay, any other folks would like to comment? Come on up. You can all come up. Just kind of move in so we don't have to, we'll keep moving. Representative, go ahead.
Thank you, Mr. Chairman. Tony Locke, Representative, House District 35. And I'm here to speak basically on behalf of many of my constituents. They're the job creators. They're the people who are looking for this workforce. And so I'm here speaking on their behalf and basically in support of this bill and the approach of trying to incentivize the workforce to get back to work sooner. Again, these are the people creating the jobs. They're looking for people to help keep their businesses going. They have the business, they have the opportunities, and I'm just speaking in favor of this and looking for opportunities to get again, incentivizing the workforce, get back to work as soon as we can and get people into the workforce. I know these people are hurting and they're interviewing folks that because they have the opportunity, in many cases, at least this is a perception, in many cases, they have the opportunity to stay on the unemployment. And they're just, anyway, I don't want to necessarily push motivation. I probably shouldn't go there, but again, on and for in support of this, just looking for methods to get folks back to work and get our businesses moving again. Thank you.
Okay, go ahead.
Thank you, Mr. Chairman, members of the committee. My name is Tammy Johnson. I'm the Executive Director for Wyoming State AFL-CIO. And we work with those people who are looking for work and labor, people who are on the job. So a recent study from the Center on Policy and Budget Priorities discusses what reducing UI benefits does. They looked at the several states that have already done it, and some of the conclusions are as follows. Economic insecurity and hardship among workers who need support while they're looking for work is a real casualty when UI benefits are reduced. It creates instability in the workforce. If you force people to go back and take a job that is in a lower skill category, we've talked about highly skilled workers, they're going to leave that job as soon as they find another one. So that employer who's looking for workers is going to be looking for workers again. So it creates a false gap there for where workers fill a gap and then they leave. So the instability cycle continues. It often results in workers just dropping completely out of the labor force. If they don't have UI benefits anymore, they're not incentivized to go look for work. And so guess where they end up then? We've already talked about we've heard a little bit about welfare, and people drop completely off of UI and then they're very dependent upon the state for their care. So that's not a situation that we want to put our Wyoming workers in. Slashing benefits does not increase employment. It's not an incentive to go back to work. In fact, the Federal Reserve Bank of San Francisco completed a study in April of 2022, and they found that UI withdrawal had limited direct impact on hiring rates. So when people withdraw out of the UI system because there's no more weeks of UI, it doesn't impact the hiring rates. Enhanced UI benefits are not an important source of the labor shortage. People are not staying out of the labor industry because they're getting UI benefits. It's kind of, I think it's kind of bad to think that about people. One of the important things about this bill that I want to call your attention to is state laws fail to take into account regional differences in job employment and job opportunities. So we're living in Cheyenne. Maybe if I get laid off, hopefully I won't, I could probably find a job very easily here in Cheyenne. If I live in Grable, that might be a different story, right? But you're being asked to pass a statute that applies carte blanche across the state with little concern for what the employment opportunities are in other communities. So I think it's very important that we think about that when we take a broad brushstroke like this and think about workers and what their opportunities are across the state. So I'll stand for any questions you may have, but thank you for your time.
Thanks, Tammy. All right, go ahead.
Mr. Chairman, members of the committee, Marcia Sheener, Wyoming Trial Lawyers Association. Our members advocate for workers, and we too stand opposed to this bill. You've heard all of the reasons why, but two points really have stuck out to me in the conversation or the comments from the folks who have talked with you this evening. Skilled workforce, and we talk about all of the time our efforts to maintain a skilled workforce in our state. And from the comments that have been shared, I think that this bill will provide less opportunity for skilled workers to stay here and to be able to find a kind of similar job. I mean, all of us have friends and family who have been impacted by oil field and mining closures and layoffs and have struggled to find similar sorts of occupations. So skilled workforce is a major point. And I also think youth. The director mentioned just some of these training programs that we are providing for youth. And that's another thing that we talk about all of the time in Wyoming. We want our youth to stay here, to have opportunities to stay here, to have opportunities for good jobs, and the training that our department provides is necessary for our youth to move forward. So for those reasons, we too oppose, and thank you. And I'm happy to answer questions if there are any.
What does the 6.5% do? Changing it from 13 to 6.5% on the. This is your weekly benefit amount under article for the week of total unemployment.
Yeah, Mr. Chairman, members of the committee, that is a special provision that's only triggered at a certain point of unemployment, and it's triggered by DOL. DOL tells us, okay, you're at this point, this triggers, and it's only been triggered twice in our history, once during COVID, for a short time, even during COVID, and then I believe it was earlier during the recession. During the 1980s. So it's a special provision, but it's utilized very, very infrequently.
Okay, further questions? Any other public comment? Any other public comment? We'll let
Mr.
you
Chairman?
close this, we'll let you bring it home.
Mr. Chairman, I forgot one thing. May I add? Yes?
Okay, go quick.
Oh, okay. One of the things we've talked a lot in this session is trying to build a workforce, and policies like this actually drive our workforce away. And I think we really need to think about that. Word gets out on the street about what kind of benefits we have in the state. And then our seasonal workers really struggle when these benefits get cut, and we do need to build that workforce. Thank you.
Okay, any other public comment? Senator Cole, bring us home.
Thank you, Chairman Nicholas. There's a lot there, so I'll try to cover with as much as I can recall. The state fund solvency trust fund, that is in fact 2.5 times more than the funding requirement that's needed. Hence the question about where the funds are going for unemployment of 60, 40, 40, 60, but we're not here talking about that. I just wanted to bring that up. We're highly funded in this trust fund. I mean, overly funded. That's one thing. Now, the question about skilled workers, which I happen to be one of them. First, anybody who tells me that I can go off and get continuing education, why I'm utilizing the unemployment system, I think is a misuse of said system. That is not what the purpose of this is to have folks go run off and get continuing education. I pay for my own continuing education. A lot of other, I'm a master electrician by trade. A lot of other electricians, they don't get that luxury. So I think that's a misuse of the system, frankly, almost like seasonal employment. That's a misuse of the system. But, you know, as a side note. Now, what is this really doing? You talk about, well, we got highly skilled workers. Well, my feelings is that highly skilled workers cannot afford to stay on unemployment. I cannot afford to stay on unemployment if I was ever on unemployment. It is a bridge to get you to the next job. And yeah, you do get a job, as I think my history goes, being employed. I got a job, I got a better job, and I got a better job after that, until I found a job that I liked. You know, that maybe suited my needs for revenue, but I certainly couldn't stay on unemployment. So I think the compromise that was talked about, well, originally going to 20 weeks from 13 weeks, I thought that was reasonable. I think it still is reasonable. I think there is an issue here in the state of Wyoming with 22,000 job openings. And I'll grant you, not every job opening fits a person seeking employment, which is 3,050 currently according to the Department of Workforce Services. Yeah, there's a lot of jobs out there, so not everyone fits everyone, you know, for a job, but there is a job. And the average amount of employment time, this is certainly way above that at 20 weeks. So I think it's a good compromise. It's a compromise that we can see what happens. Maybe nothing happens. I believe there is going to be something happen. We have to try to get employees to employers in the state of Wyoming. And I think that's a good thing. And obviously this is a policy change. It's a policy change by the legislative body. And I think the reemployment insurance name heading is certainly a good psychological idea to put in people's mind, not unemployment, but reemployment. And I think those are all good things. And I would ask for your favorable consideration on this bill. And I guess I'll stand for questions, Mr. Chairman, or I could be done. Thank you.
I did want to have another question. This says that the maximum that one can receive is $560 a week. What's the average that's paid out per week?
I'm not sure we did an average on that. I think it goes, the lowest is 38, and the highest is the 560. I don't know that we have an average.
So the lowest is $380.
No,
$38.
yes, 30. Yeah. Pretty wide range in there.
Any further questions? Okay, we'll close public comment. Discussion on the bill. Committee?
Move the bill.
Moved by Representative Stiff, seconded by Representative Larson. Discussion. Go ahead. No?
Mr. Chairman, no,
Go
I
ahead.
just think this bill could make sense. Idaho obviously has a 20-week limit. Sounds like the average is 14.7 weeks for the average person. So if we bring it back to 20 weeks, we might get people back into the workforce faster and ultimately lead potentially to lower unemployment insurance premium rates for employers.
You know, so my biggest problem with the bill for me is I just don't have enough information. I mean, you need some significant long-term data to really understand this. And it has to be out there. And other states must have researched it, I imagine. And so it's just hard to know what to do and if it would be a real benefit or not. It's just hard to say. Any other discussion? Because they have a motion on the bill, do pass. Roll call.
Representative Henderson. Representative Larson.
Aye.
Representative Sherwood.
No.
Representative Stith.
Aye.
Representative Walters. Representative Swanitzer.
No.
Chairman Nicholas.
No. So this really probably ought to be an interim study to figure this out, to know what it is. And so you might talk with us, or we'll talk with the management council and have it go to labor and have it looked at and kind of do a deeper dive on it. Because it would just be useful information to have. So. Okay, thank you. Next, let's go to, we've got our good senator waiting anxiously over there. Let's go to the Federal Indian Child Welfare Act modification.
Thank you, Mr. Chairman. I know the hour is late, but this is an important bill, so I do want to,
It's early.
is that right? So I do want to kind of give some context of why this bill is important. And then before we dive into the specifics of what this particular Senate file does. And so to do that, I just want to talk about the history of assimilation. Throughout the 1800s and kind of culminating in the late 1800s, there were a number of federal policies that were passed to really assimilate Native people into the non-Indian society. One of those was something called the General Allotment Act, and it basically authorized Congress and then subsequent reservation by reservation, divided reservations up into individual parcels that were then made available to eligible Indian heirs. And the idea was that they would convert all these nomadic, tribal people into being farmers and ranchers. And was a failed policy that passed in 1887. In 1928, a report came out that discussed the failures of this concept in this act. It found that Indian people were starving. They were dispossessed of their land because as these allotments were made available to Indians, anything that was in excess of that was made available to non-Indians. So as a result, there was an approximated 100 million acres of tribal land that was lost throughout this process. During that time, there were also federal Indian boarding schools that were started, again, with the concept of how you kill the Indian and save the man. And so one of the most notable of those schools was located in Carlisle, Pennsylvania. So you literally had children being forcibly removed from their homes in the West and going to these schools. This practice started in the 1800s, and it was really damaging to a lot of tribes and their cultures. These children were punished for speaking their native languages or practicing their culture. Their hair was often cut, and there were cases of abuse. Many children were never returned home. And if you read the newspaper, you might have heard about a recent case in Canada where archaeologists found the graves of 200 unmarked bodies of children who never made it back to their families. The Northern Arapaho tribe of Wyoming also has been undertaking various efforts to repatriate the remains of their young children, in particular, a boy who had attended that Carlisle Indian School in Pennsylvania, so that his remains could be properly returned to Wyoming and reinterred with the proper cultural ceremonies. So we talk about these things happening in the 1800s, but I can tell you that they continued on into the 1900s. My parents attended a boarding school for Navajo children. It was located in northern Utah, and it started in the 1950s. That school didn't close until 1984. My mother had attended a different school prior to that where she was severely mistreated. These were very public initiatives that were initiated by our federal government to really do what I indicated before, kill the Indian and save the man. But states also had a critical role in this assimilation effort. Studies revealed that many Native children were being separated from their parents, extended families, and communities by state child welfare and adoptive agencies. Specifically, in the 1900s, 25 to 35% of Native children were being removed from their families, and of those, 85% were placed outside their families and communities, even when there were relatives willing and able to care for these children. So as a result, or in response to this action, or these acts, Congress passed the Indian Child Welfare Act in 1978 to further stop Native children from being separated from their parents, extended families, and communities. So this act has been in effect for about 45 years, and it has come under recent scrutiny in the last several years with several lawsuits that have all been consolidated and are now pending before the U.S. Supreme Court. This is where we're going to get a little technical, so follow along, and these are important things to understand. First, I think most people are aware that our Constitution and the Wyoming Constitution prohibit race-based classifications in our laws. So you can't say we want to offer a hiring preference for African Americans to right the wrongs of slavery. Congress will look at an issue like that, or the U.S. Supreme Court will look at issues like that and say, no, there's a very strict scrutiny test that has to be met in order to do those kinds of things. So in general, we stay away from anything that triggers race-based classification in the laws. That's not true for Native Americans. Because of this relationship of the federal government that has with tribes that's established in the Constitution, the Supreme Court has identified that Congress can pass laws that identify Native Americans, provide a hiring preference, for example, within the Bureau of Indian Affairs, because the relationship isn't one of race, it's one of a political classification. So an example for that would be in Wyoming, we can offer preferences for Wyoming-based companies. We offer that preference because of their status, their political status as Wyoming citizens. That's a permissible exercise of our rights. So Congress has enjoyed broad authority to regulate Indian affairs matters, not because Native people are because of the race-based classification, but because of their political classification. That has been challenged in some cases involving ICWA. You have families that argue that this is an impermissible use of race-based classification that violates equal protection. So if the Supreme Court were to invalidate ICWA on these grounds, there's very little that we can do. However, as someone who practices in this area, I can tell you that would really upend and cause a lot of confusion about every single act that Congress passes that deals with Native Americans. So I'm not a gambling person, but I don't think it's going to go that far. However, the cases, we'll refer to them generally as Brackeen. They've all been consolidated under that name, and that's what we usually refer to them as. There are also arguments, though, that when it comes to child welfare matters, those are typically rights reserved to the states. So examples of that would include your police powers of Congress and the federal government really have little to do and little authority to regulate those kind of issues. So, and education would be another one. So there are arguments pending that say that the ICWA Act passed in 1978 would violate things like the 10th Amendment, anti-commandeering, non-delegation, Congress is exceeding its authority under the Indians Commerce Clause. So they might come out and say, in short, that even these are permissible classifications to make, but they're not the ones that the federal government can make. Only states can do it. So that's where this bill comes into place. If Congress were to go down that path of invalidating ICWA on the grounds that somehow Congress doesn't have this authority and they overstepped and they say states can do it, this would be the mechanism to bridge that. So I will provide now an overview of ICWA. It's a long bill, but when I visited with the LSO and asking for the drafting of this bill, I made it very clear that I don't think Wyoming should be imposing any of our policy preferences in this bill. The request really was a codification of the federal requirements. So if it's okay with the committee, and this expedited it on the Senate side, I will go over it with some broad brushstrokes and then take questions at the end so that maybe you get a whole picture of what this act does. So pages 1 through 5 provide definitions. You'll see child custody proceeding, extended family member, Indian child, and that definition includes members of a tribe or those who are eligible for membership. with the definition of what an Indian child's tribe is, Indian custodian, Indian organization, Indian tribe, parent, and here the definition includes biological parents or the parent of an Indian child or any Indian person who has lawfully adopted an Indian child. The definition of reservation, definition of shelter care, and you'll see this is cross-referenced with an existing definition found in our Wyoming statutes in Title 14, as well as the definition of tribal court. Pages 6 through 7 is a really important. Yep, Mr. Chair.
So thank you, Senator Ellis. And those definitions, I believe, in my study of ICWA, particularly on tribe custodian and parents, really reflect the heart of ICWA, which is getting back to the cultural difference between what the European family perhaps looks like and what you've seen culturally in tribals. And so it tries to accommodate that, which is historically been kind of led to about 80% of all tribal homes having a child taken out. Am I seeing that accurately?
I think you're seeing that accurately.
Thank you.
Page 6 and 7 talks about jurisdiction. Here on page 6, it said tribes have exclusive jurisdiction over any child custody proceeding involving a child domiciled within the reservation. If an Indian child is domiciled on the reservation and there's a state court proceeding involving placement of that child or a termination of parental rights case, paragraph B describes the process of how the state court is required to transfer that case to tribal court if a parent or custodian petitions the state court. Page 7, this explains that if there's a state court proceeding under paragraph C, that the child's tribe has a right to intervene in that state court proceeding. That right's automatic. Usually, if you want to intervene in cases, you have to prove certain elements. This provides an automatic right to intervene. Lines 11, I might have my lines off here just because I had my notes prepared for the unengrossed version. You have the engrossed version, but you'll see language in there that Wyoming will give full faith and credit to tribal court orders. Pages 7 through 10 cover matters with involuntary proceedings in state court. You'll see a duty to notify parents of their rights to intervene. If the state court finds that the Indian parent or custodian is indigent, meaning they can't afford an attorney, the court shall appoint counsel for shelter care placement or termination of parental rights. You'll see some language about the right to examine certain reports. And then on page 9, this talks about the burdens of proof. Here, clear and convincing evidence would be required for custody matters, and beyond a reasonable doubt would be the standard for termination of parental rights. Pages 10 through 12 cover matters involving voluntary placements. This ensures that an Indian parent who consents to the placement or termination of parental rights fully understands what was happening. This allows parents to withdraw their consent before the final decree of termination or adoption are entered. And it allows Indian parents or custodians to invalidate an action if a court of competent jurisdiction finds that the state court violated these provisions. Pages 12 through 15 provide a preference for Indian child placement, and this is very critical. For adoptive placement, the first preference would be to the member of the child's family, second to other members of the Indian child's tribe, third to other Indian families, and then fourth, any other placement. However, tribes may adopt a different preference through tribal ordinances, and the state law would conform with that, with obliging to that preference. And then courts and family service agencies would be required to keep records of each placement of Indian children. Then the following are the miscellaneous provisions. Pages 15 through 16 deal with the return of custody if a final decree of adoption has been vacated. Pages 16 and 17 deal with instances when an Indian child reaches the age of 18 and that their ability to receive information about their tribal affiliation. Page 17, and this is important, talks about agreements that may be entered into between the state and other tribes concerning the custody and care of Indian children. And I want to thank my co-chair of the Select Committee on Tribal Relations. That task force, which is a companion bill to this, I think really allows us to maybe have some conversations that were long overdue, making sure that we have extended our hands to, or extended our interest and willingness to work with our tribes to see if there are ways of doing it better. So that would just be codified in this bill as well. And I think would be authorized under the task force. Page 18 provides remedies for the improper removal of Indian children, and it also clarifies that if there's any applicable federal law that provides a higher standard of protection to the rights of an Indian parent or custodian, that a court should provide that higher standard. Page 19, and this is going to be important for you to also notice. This clarifies that nothing in this act should be construed to prevent the emergency removal of an Indian child to prevent imminent physical damage or harm to the child. As we worked on this and had some conversations in the interim, I think anytime you're dealing with family matters, you're always going to hear a really awful story of a family or a child who's been abused and how that child is maybe slipping through the cracks. I understand that, but there is a duty that says if that child's in imminent danger, that the state can take action if they're the immediate custodian of that child. Pages 20 through 22 maintain requirements to report information about state court proceedings involving adoptions to the Department of Family Services and the U.S. Department of the Interior. Page 22 provides the Department of Family Services with rulemaking. And then pages 22 through 31 are largely conforming amendments. Title I deals with your civil procedure title. Title 14 is our children's code. Title 20, domestic relations. Title 21, education. And that would be it. Darn it. Trying to move through it, sir.
Thank you, Mr. Chairman. So sorry to break your stride there. I just want to go back to page 23 just for clarification. And I think it has something to do with disclosure of documentation. Line 17 refers to sections D and E of Title I, Chapter 22, 104. Could you just help me understand what those two sections deal with, sir?
Mr. Chairman, could Representative Henderson please repeat the question? I am a little tired and I couldn't see.
sorry.
I wasn't following along. I'm
Go to
sorry.
page 23, Mr. Chairman, line 17. It says notwithstanding subsections D and E of this section. That's 122, 104. Right. And I think it has something to do with, the documentation relative to the adoption. But just briefly, what are those sections?
Mr. Chairman, I can take a look at those. I don't have my green books in front of me
I
or
can
my
look it up.
computer. I
can
think
look
these are intended to be conforming amendments with our existing titles.
Okay, further questions? Go ahead, Representative Stiff.
Mr. Chairman, yes, I've got a question back further on page 9 at the bottom. Line 22 and 23, and then over to the next page, lines 1 through 3. This provides that no termination of parental rights over an Indian child shall be ordered unless the court determines beyond a reasonable doubt that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. So that seems like a pretty unusual provision just because this is would be a civil proceeding. Is there any other instance in a civil proceeding in the state where we have a beyond a reasonable doubt standard for a civil proceeding?
Mr. Chairman, Representative Stith, I would agree with you. This is unusual. And usually when I see these standards being intertwined or interjected in other circumstances, I resist that as well. This is the federal standard. And if I could maybe just conclude by saying the act would take immediate effect, and I can hopefully bridge why this is important. I think our concern right now is if this, if we're codifying federal law, this is consistent with what the requirement is today. So this is the practice. This is the law right now. Our state courts should be using these standards if they're involved in these types of proceedings. So the court has heard oral argument on the Brackeen decision. If they issue their decision sometime in early summer and say if we don't pass this, if they don't invalidate ICWA on the race-based classification, just say it's a federal overstep. The states need to regulate this if they want to have it. I think we're going to have confusion over what we should be doing with our Indian children. I think you'll see our tribes saying, well, we want the status quo maintained. Right now, if there's these proceedings, we notify the ICWA coordinator on the reservation and we follow a process that's already in place. If we don't have this in place, I think family services might be saying, well, wait a minute, do I have to do that? Should I do that? The tribes will say, no, we want you to do this. So I think we'll start seeing that confusion there over because we haven't made a statement on it already. So one example where we've seen this happen already this last year was it was longstanding knowledge that states had limited jurisdiction on criminal matters involving interracial crimes. So if you had a non-Indian offender committing a crime against an Indian person on the reservation, prior to this last year, the states had no jurisdiction and wasn't exercising their jurisdiction. That was kind of the understanding out there in federal Indian law. This last year, the Supreme Court reversed this longstanding precedent and said, no, actually states do have jurisdiction. They might have concurrent jurisdiction. So then people on the reservations are wondering, well, is Wyoming going to start exercising this extra jurisdiction? Our governor has, I think, made some public announcements, and I could be wrong if I'm misquoting, but saying, well, no, we don't think we're going to leave the status quo as it is. But what if in the future you have a Fremont County prosecutor that says, well, I disagree with the governor, I'm going to start filing charges. So because we haven't addressed it, I think that's where the confusion is. And that's actually my concern in bringing this bill, is to provide that continuity until we know what's happening. So if the court comes out with their decision, this is in place, we have a task force, then we can start looking at whether or not we want to refine this. But I think if we do that having those conversations with our tribal partners. I hope that makes some sense.
Mr. Chairman, but it seems like the issue is not whether people are confused. The issue is whether, I mean, the federal government in 1978 thought it was a good idea to have a beyond a reasonable doubt standard for termination of parental rights for Indian children. But that's not the issue what the federal government thought. The issue is that a good idea for us here? And it just seems very odd in a termination of parental rights situation to have a beyond a reasonable doubt standard, because it seems like it's a practical matter. That means it just won't happen.
Mr. Chairman, follow up. So I don't necessarily disagree with you, but I'd say if we were to change the standard and the burden of proof here, we would be inconsistent. This would be inconsistent with ICWA as it stands today, and this wouldn't be valid. So again, I'm not saying that this is an intent. When I spoke with LSO, was an intent to codify the federal regulatory framework till we know what happens at the federal level or at the US Supreme Court level. And I'd also say this, I thought a lot about whether or not to bring this bill. You know, there'll be questions about why don't we wait? Again, I'm just worried about that bridge period because we are dealing with kids and we don't want to get it wrong. This at least allows us to bridge the gap until we know what's out there. And then if we need to refine things and have that conversation further, then we can do it in the future.
And so I had the same question on the burden of proof there, and sent an email to the good director, Department of Family Services, and says, do we have this high bar other places? And so maybe she can address how we do that otherwise. But I think Senator Ellis, what we've discussed in tribal relations is, as we've looked at this, is that we've got two mechanisms there to address the placement of Indian children. One is to have this in place for a bridge until we really know what the Supreme Court's doing. And then this task force that we've put in place to then address the shortfalls or the portions of the codified law that we feel that we need to change and can address the changes that perhaps might come with the Supreme Court ruling. Is that fair and sane?
Yes, Mr. Chairman, this is intended to be a bridge. And like all federal laws, that always provides the floor of protections, not the ceiling. So if a state wants to take action that provides greater protections, we can do that, but we can't provide less. So I think if right now we were to pass a law that said we're going to change the burden of proof to lesser standards, we've automatically created confusion. And I think that our statute then would start falling apart. So this is messy, and this was my attempt to try and get us there without having to do a trigger bill.
And then Senator Ellis, I think for the most part, and would ask for clarification from you, is this is a big impact on Fremont County, when in reality, Fremont County is probably the least of our concerns, because most of those cases there with children are handled in the tribal courts, and the work that's done between our Department of Family Services and the tribes, those go through the tribal law and order in the tribal courts and the placement there. It's the rest of the state where we have Indian children that are being, the disposition of them being handled by a district court. And now, you know, how then would they handle that without direction? And am I seeing that accurately?
Mr. Chairman, yes, this applies to any of our 500 plus federally recognized Indian tribes. These notice requirements exist, and you'd be amazed at, you know, tribes have designated ICWA people that receive these. And there are instances where, you know, tribes say, we don't know that family, we don't know that child, we got the notice, but we're not going to intervene. We're not going to ask for that case to be transferred to our tribal court. That happens. But it is our duty right now to notify if we have reason to believe and know that that child is a member of a tribe or eligible for membership.
Other questions? Public comment or any other additional comment? Does the
Mr.
department
Chairman?
come up?
The last thing I'd say is this is supported by both of our tribes.
Good evening, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. And more than anything, I'm here for questions. If you have any questions.
So if you could briefly just share with us from your position in administering these issues, any concerns that you see if we don't have something in place to do that? Is this a valid concern that we're trying to address? Do you think you have it taken care of?
Mr. Chairman, Representative Larson, I think the issue is what you had just commented on most recently, and that's in regard to the other children that live off the reservation that aren't necessarily affiliated with either the Eastern Shoshone or Northern Arapaho tribes. We have about 30 cases a year that involve ICWA that are outside the contractual agreement we have with the Northern Arapaho and the Eastern Shoshone. So what that means is that any one of those 30 children could be affiliated with any one of the 500 or so tribes, and the relationship we have then in those situations will be very confusing. How do we place? Where do we place? I mean, our instinct will be to look at placement with family because that is the first place that we do look in any one of our cases. But all of the arrangements that we have right now that help us connect with the tribe, find the person who is the ICWA professional for the tribe, and then start those conversations, that's going to be thrown into question. And then we will potentially have 30 children that then we're really struggling trying to figure out how to work with them and placement in any one of those tribes. So the mechanism is important, I think. It does, again, as Senator Ellis mentioned, these are children. And so the longer it takes for us to figure this out, the longer that those children are sitting in care and don't have the connections back to their family potentially.
Any other questions? Okay, go ahead, Travis.
Thank you, Mr. Chairman. Travis McNiven here on behalf of the Northern Arapaho Business Council. The council sends their apologies that when this bill was in the Senate, co-chair Karen Returns-Tor was able to testify, share a little bit about her family experience, and also share the council's strong support for the bill. They are all currently en route to Cheyenne this evening for events tomorrow, and so just could not join in, and so. But to Senator Ellis's point, very much strongly in favor of the bill, appreciative of the Tribal Relations Committee work, both on the task force bill as well as this, and addressing and what could be the gap on a lot of uncertainties that may or may not, depending on which part of either the political class question, race question, or the 10th Amendment state authority question has been outlined there with the Supreme Court, and what does or does not happen there this summer, and then allow for potential additional clarifications, through the task force or other changes that would need to be addressed to this once further knowledge is known, from the Supreme Court. So view this as a very important step, both this and then the task force, to create the least amount of uncertainty between now and what may or may not happen with the Supreme Court, and would certainly take any questions at this time. Thank you, Mr. Chairman.
Questions for Travis? Okay, any other public comment? Ilona?
Mr. Chairman, Kit Wentland, Special Counsel and Tribal Policy Advisor for Governor Gordon's office. I'll be short and sweet. The governor's office, along with the Northern Arapaho tribe, and I understand the Eastern Shoshone tribe, Senator Ellis, we do support this bill. I, of course, defer to our DFS Director, Director Schmidt, on the mechanics of the current system. But the need for this bridge in the short term, should something happen at the Supreme Court, I think is real, with the complications that can happen. In conjunction with the companion bill about a task force to look at how this would work long term. The governor is willing to participate in that process and make sure the system works. Just believes this supports tribal sovereignty and also supports the status quo and the system in Wyoming that's been in place for a long time. With that, I'd stand for any questions.
Okay, appreciate your testimony. Anybody else? Okay, we'll close public comment. Moved by Representative Larson, second by Representative Walters. So when's the last time we adopted a whole federal statutes to, or a race to protect ourselves against the federal government? Go ahead, Representative Stitt.
Mr. Chairman, no, that's precisely my point. This bill is extremely unusual because we are, again, as you say, being asked to adopt a federal law as Wyoming state law, which may or may not be a good idea, but we can't mark up the bill because we can't adopt something that would violate federal law because the federal law is still good. To me, it just seems like it's too early to take action on this. I don't think the system's broken. I just don't see the sky falling if we wait and see what the Supreme Court does. It seems early because it's.
We don't even know what we're adopting. You guys know, but we don't.
And Mr. Chairman, the comments are really interesting because as over the last year, I've been trying to get my head around ICWA and read, and as we've heard, and what we found is that there's, what I found, that there are a number of states around the country that, for one reason or another, didn't like ICWA. So then they create an amendment in state statutes to address the portion of the federal statute that they don't like. And then that has caused problems. And then it's just been it's really a fascinating set of events that go around with this whole conversation. And then there's been some states that have brought the federal regulation into their state statutes, then address some of the gaps that they found. And we heard from one of the leading ICWA law professors from Michigan State in one of our tribal relations meeting that then they adapted, and because everyone acknowledges there's some needs to fix a few things, they kind of have an idea where they are. So your point's well taken, Representative Stitt. There's just some interesting things with that. I've got the book if you want to borrow it.
So what are the nature of the suits? I mean, are they challenging? How diverse are they? Are they all constitutional issues basically? And families and adoption?
Mr. Chairman, I again don't have all of my notes in front of me, but the nature, they tend to be mostly constitutional. If recollection serves, there were 3 consolidated cases. One has been the big one is the racial classification. That would destroy the entire practice of federal Indian law, in my opinion. But the other one, I think, 10th Amendment, Indian Commerce Clause, like if the Supreme Court were to come down, that's where this would really come into play. So I mean, I appreciate the concerns. I've thought about this a lot. What if we don't do anything? And that was a position I was at, and my good chairman knows this. Months ago, I said, let's just wait and see what the court does. I don't want to do a trigger bill, blah, blah, blah. And then laid in bed at night and just thought about the confusion that's out there on the jurisdiction for prosecuting crimes committed on the reservation. There are questions, and it's a mess out there in Indian country. People don't know what's going on. In my view, we just can't afford to get this wrong. If we start having kids that are not being placed properly or what have you, then we're ripe for more challenges. And the more we get that wrong, the kids are the ones that are going to suffer. So, I truly understand your concerns. I was there months ago, but this is something I've thought about for a while and laid in bed thinking about, worried about. And so here we are today. I think this is the best course. And I'd say it really is a compliment to the task force. I think we probably have been long overdue for having that task force come into play, having some conversations of how can we do things better? How can we work with our tribes? And we can mutually agree to things that, the conversation about the burden of proof, add that to the task force list. Like, is this the appropriate standard if we have that wiggle room? I think that there are a lot of those things. This is our first attempt of like really looking at this issue. And I remember years ago, a legislator talking about, sometimes we have the desire when we make laws to just be done with it, look at it once and then we're done. And this legislator said, no, it's more like doing the laundry. You put a load in, you get some stuff done, then you start seeing more things pile up in the basket you got to address. I think it might take us a little bit of time to get this right. So this is, our toe in the water, have the task force figure out some of these outstanding issues. But I really do think they go together, the timing of it.
Why wouldn't you either do a sunset clause? Or in the alternative, you could make a trigger so that this doesn't come into effect until and unless certain things occur.
Yeah, Mr. Chairman, I think the certainty of it, the court might, and you know this better than anyone, sometimes when the court remands things, it leaves open some unanswered questions of issues that need to be resolved, and that process isn't always fast. I think the only time we'd really look at repealing this would be, if there was that dramatic shift that does away with ICWA entirely. We can look at that down the road when it happens. But I just think the permanency of having it in statute, this is something that we do in a lot of other contexts when it comes to environmental regulation. There is that kind of the federal umbrella of what the structure that's in place, and then we fill in gaps. I think that this could be, I kind of view this in that same light.
When I read it, there are lots of things that if we were going to draft our own Federal Indian Child Welfare Act, would be different than what's written in here. And so at some point, assuming that, let's just say that it is found to be racial classification or violation of the 10th Amendment, then we'd have to come back in at some point and just essentially through probably your committee is review these and then get public input on them and rewrite the laws consistent with what Wyoming wants versus what was adopted by the federal government in 1978. I presume that would probably be what happened. Would you agree?
No, Mr. Chairman. If the race-based classification is the reason for throwing it out, then probably we could repeal this. If the other arguments that it's exceeding Congress's authority, whatever, then we would have the authority to amend this and Wyomingize it. If the court says nothing and says, no, we don't see any problem with it, this is the law of the land right now. All of the regulations, all of the practices the Department of Family Services use when it comes to Indian children are based off this law right now. So it may seem unusual, but this is happening already right now. This is just the bridge in case something happens. This prevents our kids from slipping through any cracks.
Mr. Chairman.
Go ahead.
So Senator, you mentioned earlier that the kids will suffer if we don't do this. But what's sort of striking to me about, for the most part, our regular family law and custody cases all revolve around what's in the best interest of the children. But ICWA makes a slightly different choice. ICWA says, look, we care about the best interest of the child, but what matters most is the placing the child, say, with the child's extended family, other members of the child's tribe, or other Indian families. And that's different than best interest of the child, right? And so it seems to me that if best interest of the child is what we care about, then our best play here is to do nothing and see what the Supreme Court does. Isn't that right?
Mr. Chairman, no. I think if you look at other states and what they identify as what's in the best interest of the child, having that child stay with family members and within their community is part of that calculation of defining what the best interest is. And so this is very consistent with what a lot of other states do and how other states approach it. So I would disagree with the characterization. What this is intended to prevent are automatic assumptions that placement out of an Indian home is always going to be better for a child. And, to really put a fine point on it, that is why I really tried to impress on this has so much more than just what you see on the piece of paper. This is hundreds of years of assimilation policies, families that are still hurting from their kids, that presumption that it's better to remove Indian children from their Indian communities and their Indian families. That's why this bill was, enacted in the first place. And that's why it's very sensitive right now. So it is to prevent that from happening in the future. And that's why I think we need to have it as a bridge in place if something were dramatic to happen at the federal level. And I do want to offer, there's always the chance. The US Supreme Court says ICWA's fine and brushes away. This is consistent with what we do now.
So is this verbatim? The federal statute?
Mr. Chairman, I haven't done the side by side, but like I said, when I asked LSO to draft the bill, I said, I don't want any Wyoming, any of our policy preferences. I really am asking for a codification of ICWA and the codification of ICWA. There are additional provisions at the end of ICWA that talk about grant making and some other things that are really unique to the Secretary of the Interior. This does not include those kind of things.
How did the attorney's fees get paid and the appointments through ICWA?
I can't hear you. I'm sorry.
How did the attorney's fees and costs get paid that they talk about in here?
There's
Appointment.
silent. They're not addressed in the federal law.
So who pays them?
That's a great question. I don't know.
Mr. Chairman, about who pays for the attorneys. So if we have a child, an Indian child that appears in district court, then of course the fees that are paid by the Department of Family Services, by the state guardian ad litem program, that's who will pay for the legal representation. If the child is transferred to the jurisdiction of the tribal court, then the tribe then will start to assume whatever financial responsibility for legal fees there are.
And so then if this person, let's say the child is in Cheyenne and they want to transfer to tribal court, how does that happen? Do you have to transport them somehow and accommodate transportation to it? Because it's automatic if you ask for it, right? If any family member basically asks for it.
Mr. Chairman, like any jurisdictional issue, if there's a child, for example, from Montana that comes into care in Wyoming and we have to transport it to Montana, we'll do that. So yes, we make arrangements all the time. Regardless of race. Right. Correct. Any child that comes into custody. So what ICWA really does for us is it helps us with the jurisdictional issues. And I think by way of an example, up in the northwestern part of the state, we have Yellowstone National Park, we have Montana, we have Wyoming. So we have really difficult jurisdictional issues there when a child comes into care. If a child's been abused and neglected, comes into protective custody, it's a battle to figure out who does what. And most of the time, because it's pretty infrequent, it's a case by case, but we do try to maintain relationships up in that corner of the state so that if there is a child that comes into custody, we know who to call. Again, if ICWA is overturned and we don't have the bridge, then what we will be doing as the state agency is having to then try to do all of that times 30. So we are looking at jurisdictional issues for 30 kids that could be anywhere, Alaska, wherever. So that while it seems to be a minor issue in dealing with 30 children with that kind of complicated casework, that can get very difficult in the amount of time that it could eat up, not just by our caseworkers, but we're going to have attorneys generals that are going to be involved, that they're trying to contact tribes and get a hold of them. Or do we, searching for family is also a difficult issue, but we are dedicated to looking for family and looking for those relative placements first, because we want to decrease the amount of trauma that a child goes through. Removal of a child is extremely traumatic. And so when we do that, when we're forced to have to have that kind of intervention, we want to do our best to put that child with someone they know. We want them to be able to wake up the next day and have a surrounding at least that is somewhat familiar, because again, continuing the trauma, that removal by placing a child. Because we just decided that was what was easiest, really is not in the best interests. And so best interest of the child does come into play with placement. And as the senator mentioned, they do kind of come in altogether.
Daphne, do we know how many, if any other states have basically adopted ICWA into their codified?
Mr. Chairman, I think 10 or 11. And then I've read some articles about 4 or 5 states are looking at it right now.
And part of that process also depends on the status with the tribes. If they're a PL 280 state where the states have jurisdiction over the tribes, that changes a little bit. And so these are, I think, the non-PL 280 states. Is that right, Senator Ellis? Like us.
Look.
Okay, any further questions?
Question?
Okay, we'll close public comment. Moved by Representative, moved to pass by Representative Walters, seconded by Representative Larson. Any discussion? All right, roll call.
Representative Henderson. Representative Larson.
Aye.
Representative Sherwood. Representative Stith.
No.
Representative Walters. Representative Swanitzer.
Aye.
Chairman Nicholas.
Aye. Okay. Moving rapidly. Here we go. All right, let's jump to the water bill. Thanks for presenting. Daphne. All right. So we were gonna get some information from you for somebody. Did we? Where is it? Yeah, I haven't seen them. Yeah, that'd be great. Thanks. Okay, what do we got? Specs.
So this talks about, Mr. Chairman.
Oh, the positions, right? Why don't you just walk through these so we can, I don't have my peeps up here, so I can't read it very well.
Mr. Chairman, Jason Mead with the Water Development Office. I'll invite the state engineer up here to walk through their portion of that.
Great.
So really just the first part of this is just a comparison between what the state engineer's office and the Board of Control does versus what the Water Development Program does. And generally, in simple terms, they regulate water, take care of water rights applications, things of that nature, and we plan and construct new development or water projects for the state of Wyoming. And then as far as the positions go for the state of Colorado, I'll hand it over to Brandon to talk about the state engineer's office positions first.
Thanks, Jason. Thank you, Mr. Chairman. Good evening, Brandon Gebhardt, State Engineer. I believe that this handout was meant to address, I think, the questions that the committee had. And particularly with our budget, with our supplemental requests, they fall under the 2 categories. One is I call it a supplemental budget request, but this was actually brought up as an amendment during our budget hearing in front of Joint Appropriations. This was something that we had talked about internally. We had a process where we were going to suggest our proposal to the governor's office, but that amendment occurred before we got to that point. So we held our request to the governor's office on that, but that was for $500,000 in an increase in our 900 series for contracting work, and then one full-time equivalent. And then the other FTE was associated with House Bill 222. And I'm not sure what the status of that bill is right now with amendments or anything like that, but those were the two positions associated with our budget.
And so tell us about the two positions and the need for both of them.
Okay, Mr. Chairman, I'll start with the supplemental budget request. And so what we anticipate this position to be would be similar to an assistant superintendent in the Division 4. That's in the Green River Basin. And we've got a lot of things occurring, and more things occur every second, it seems like. But really what I would think, some of the things that they're working on that this position would help would be, if curtailment were to occur, we're trying to prepare for the administration of how that would occur. And so some of the things that we're lacking and trying to get our handle on, and one of the big things is a basin-wide priority schedule. That would be a priority schedule of all the water rights, and how would we administer those rights? What rights do we shut off and when? And then complicating thing to that is we're very good at regulating water based on diversion rates, because that's what we do. Something that's different in the Colorado River Basin is it's based on consumptive use. So we have to calculate what is the consumption of each field that we're shutting off, and calculate that and shepherd that water, that amount of water to the state line. That essentially leaf areas where it needs to be. So we need to figure out the priority schedule on a basin-wide system. We have to figure out how to shepherd that. We have to know where the head gates are that divert the water, what those head gates feed, what fields they feed. We estimate we've got over 2,500 ditches in the Green River Basin alone. And so we need to inventory all of those. We need to understand what water rights are in each ditch, what water rights go to what lands, and which are in priority and what are not. We do regulate some of the streams on a regular basis.
I say, don't you have most of that information?
We've got the information, but we don't have it compiled in the way that a curtailment would work, because we do regulate individual streams, but this would be basin-wide. So we take each individual little tributary, we have to lump it all together, develop a new priority schedule, and then we have to figure out like I said, the consumptive use. So that's a lot of effort that we're going through. We're trying to do some mapping as well to assist with that. And so those are just some of the things that this employee would help our superintendent with. I did talk to the superintendent right now, and last year, I think he worked probably 16 or 17 months in the 12 months. So the equivalent of that. And so trying to get him some help on addressing some of these issues is really the intent of that FTE. And I don't know if I explained enough of that, but I'd be happy to answer any other questions. But, you know, really with all the things going on, every employee that we would get, we're going to keep them busy. And I do anticipate that next year you'll see me asking for more positions. One of the things we just have not had time to do is to develop a work plan and a staffing plan. That's something that we will work on. I really think that that's something that this position would help with as well.
Question, how many, I'm sorry. Did I hear you right that you anticipate the possibility of additional FT? Was it one or was it multiple?
Mr. Chairman, next year it would likely be multiple. And part of that depends on the condition of the state of affair in the Colorado River as well.
Go ahead.
Thank you, Mr. Chairman. This might be a dumb question, Mr. Chairman, but we've always had the Colorado River, we've had the compact, and I guess I'm asking, what is it that we're going to have to do now that we didn't have to do already?
Mr. Chairman, I think one of the biggest things that we're looking at right now is very poor hydrology in the basin that I don't think we ever anticipated in the 100 years of the compact. And it's decelerating quickly, or accelerating. The issues are accelerating quickly. And so we are involved, our agency is involved in 42 committees and or task force that are what we attend, meetings. And because of the condition of that, these meetings are more frequent. They take a lot more of our time, and we're just really trying to get ahead of a potential curtailment that is closer now than it's ever been. I'm not saying that it's going to happen, but it does not look good.
Okay, other questions for the? And so, and then you've got the other FTE, the state engineer's office, is that position filled?
Mr. Chairman, the one from last year,
Yep.
we are going through, I'm reviewing the job. During our budget session, I suggested that maybe we open that back up to a wider area. We're redoing that advertisement right now.
Just a different classification.
It'll same classification, but a different geographic area, broadening the geographic area. So I suspect that will be re-advertised within a week or two.
Oh, yeah, and that was to capture someone that was qualified over in Sweetwater County.
That's correct.
Yeah. Okay, go ahead, Jason.
Okay, Mr. Chairman, that bottom block, so within the planning bill, the Select Water Committee added a full-time employee to the Water Development Office. And that would be just for fiscal year 24 in regards to the general fund funding. After that, it would be absorbed into our account one funding that would usually go to pay for our office budget. So it'd be 1 year out of general fund in fiscal year 24. And what that really is reacting to some of the Inflation Reduction Act funding that's coming to the upper basin states through the Upper Colorado River Commission. Right now, I think there's roughly 125 million. They've alluded to additional funding in the future to get a hold of this or get a handle on drought resiliency. And so it's really just put an emphasis to try to leverage that funding and recognizing that there's maybe some capacity issues within local governments such as conservation districts within the Upper Green River Basin. To be able to monitor that, understand all the requirements, actually apply for that funding, then work with the local conservation districts and NGOs, the Trout Unlimited, to try to form partnerships and develop these matching funds to actually get projects put together and then work with the conservation districts to get the projects on the ground, but take care of more of the federal requirement piece of it. So that's what the emphasis of that full-time employee would be doing, would be really to bring federal funding to Wyoming.
You mean by matching dollars or?
Correct. So a lot of times federal funding isn't 100%.
Yeah, I think they said it goes anywhere between 20 to 90%.
Yeah, 75, 20, yeah. The $500,000 is, again, that's a one-time from general fund. And that's really just with our experience working through some of these federal programs. You have to put together feasibility studies, which a lot of times cover a number of topics. And we need to be able to rely on, consulting firms that would have a number of different professional disciplines that we could pull from. We wouldn't necessarily have all that expertise on our staff within the office.
So this
So
goes into your 900 series.
that's correct for contracting with consultants. And then the last 500,000 in the omnibus planning bill, again, is a one-time from the general
Sorry to
fund.
Interrupt, Jason, but
No problem.
remind me of that 120 odd million you're talking about from the Inflation Reduction. Those are particular types of water projects, right?
Typically, they're water conservation type projects. So we don't have all the details yet, but we anticipate they'd be putting ditch in a pipe or lining ditches and reducing consumptive use.
And do you anticipate, that's over what, a 4-year period, right? I think goes through.
Mr. Chairman, I don't
Yeah, I
recall
think
for
it's
sure.
5 years next. When, so it's a certain amount of money. That's my question. Is it stretched out over time or is it, someplace I've got my IGA outline here, but I can't find it. That's what I'm just curious about.
Don't know if I have
Mr. Chairman, I want to say it's through 2026, but I'm not 100% on that.
Yeah, so they've got, implementation in 24 through 26, but I think they've been talking about,
Expanding it.
expanding that into the future for further resilience.
Are those the same funds? Are they tied to the clean water? Are they separate from the clean water drinking and the clean water, the drinking water and the clean water stuff? Are they all tied in together? Just
Mr.
forgive
Chairman,
my ignorance.
sorry, Mr. Chairman, Representative Larson, they're separate from like this drinking water state revolving funds.
In addition to.
Yeah.
Correct.
Okay.
Those mostly came through bipartisan infrastructure law. So, Mr. Chairman, the last piece would be the conveyance loss study of ditches within the upper Colorado River Basin in Wyoming. And again, that's really to get a handle on the conveyance losses, as the title would, and really the consumptive use piece of that to help inform not only the curtailment and regulation associated with that, potentially modeling, but also to get an understanding of where we might get the most bang for the buck with some of these projects. Leakier ditches, that might be low hanging fruit that you'd go after that federal funding for those particular projects first. And this is it's a first step. It's kind of a big undertaking to try to get regional estimates of conveyance loss and consumptive use throughout an entire basin like this, but we've got to start somewhere. So.
Mr. Chairman. So, do I read this wrong? But it appears that overlaps to some degree with the efforts up in the state engineer's office to do the analyze and feasibility and establish the demand management program. Do those tie together somehow, or am I just not understanding?
Mr. Chairman, Representative Larson, they look similar. And they do. And I don't think that they really are similar. What we're looking at is collecting data, like I said, that would help us with the administration. What Jason is looking at is helping communities or helping these individuals determine that if this funding is available, so there's IIJAL or whatever the acronym is going to come out with additional money. So we've got the system conservation pilot program money that's starting right now. Bucket 1B is part of that. And then their bucket 2, they call it, is still coming out. We don't know the details of that, but that is for longer term conservation projects. And so I think what the money in the omnibus bill is looking to establish better information to help the water users make a better case to apply for that money and be competitive. And then what in the state engineer supplemental budget, we're looking more at the data that's going to help us with curtailment. It looks at some of the same things, but the ditch conveyance study is more defined to a ditch. And some of the studies that we're looking at, conveyance losses, CU, the conveyance losses is on the streams and the main Green River and all the tributaries. A much broader look to help us with the curtailment. And so they do look similar. I acknowledge that, but they really are intended to be two different purposes. Thank you.
So is there, my understanding is that there's IIJA money, funds available for administration as part of it. And also then could be also used for personnel. That's what, is that accurate or do you guys know?
Mr. Chairman, it's my understanding that that administration is through the Upper Colorado River Commission. So they're eligible because all of that money from the federal government goes through the UCRC. So they are eligible. But I am uncertain that state of Wyoming would be eligible for the administration money of that funding.
And well, do we know that yet? Is that promulgated the rules for it yet?
I don't know that we would have that ability. It's unknown at this time. The assumption at this point, is no, but it could change.
So are you guys ready to pack up and move your office to Riverton? You're gonna take a survey?
We'll take the survey, Mr. Chairman.
Okay, further questions? Further questions? Chairman Eklund, you want to comment? Or you got any feedback or? So what we have, we prepared a draft amendment to Senate File 96. But I think after reading this, we're probably going to have to put our heads together and decide what we're going to do.
We thought we had a plan.
Yeah. So we might be a little nicer than we were last time. We'll see. That's just, it's always a possibility.
Don't tell Eklund.
But what we what we want to do is do it in such a way that we kind of encapsulate what's in the budget, what's in the other omnibus bill, and put it all in one bill, in one spot, so that we're not all over the place. And then, because this is the last bill, and if it'll be the last one that comes out, theoretically, it will control. And so that's kind of what our game plan is, just so you guys know. But before we finalize anything, we'll show you the draft of where we're at and let you comment on it again. But I think we're gonna not work it further tonight. We're gonna have to have some more tinkering. That's what happens when you give us a bill to play with and a lot of free time on our hands.
Well, Mr. Chairman, tonight's been very helpful to help us bifurcate the differences between the two, because us non-water guys just see words are the same, so it helps us, and I agree, so we're getting there.
Okay, sorry to keep you guys so late.
No, Mr. Chairman, and I would offer, if you have any questions as you're working through this, please
Yeah.
don't hesitate to contact
I
us.
appreciate it. Yeah, okay. Thanks, Jason. Okay, we got a quick re-referral for 61. Any public comment on the re-referral? Yeah.
Some of these bills back in our folder, we do not pitch them.
Oh, I won't pitch them. No.
Any public comment on Senate File 61? Seeing none, we'll close public comment. Is there a motion?
Move the bill.
No, it's really simple.
Mr. Chairman, I move the bill.
Roll call.
Representative Henderson. Representative Larson.
Aye.
Representative Sherwood. Representative Stith.
Aye.
Representative Walters. Representative Swanitzer.
Aye.
Chairman Nicholas.
Aye. Okay, anything else for the night?
You do have Senate File 66.
66.
That amendment.
Yeah.
45%.
What's that? It's 7:30. We could do it, but why? So the good vice president wants us to put a sunset date on the or some type of a trip, so that at some point in the future, when the Common Schools Reserve account reaches 7x, that it stops. Meaning that And then he just came and talked to me about it. I mean, that's what he wants. And so regardless of what we do, that will probably be the issue on conference committee. So the question is, do we do it? Okay. Yep. Yeah, let's do that. Okay, so with that, we'll meet at noon. I've got a 1 o'clock meeting, so I might have to get up and leave, but because we've got 2 bills, 3 bills.
Want me to just shut this down?
Yeah.
Okay.